What's up? What's up, y'all? It is your girl Survivor Speaks. I hope y'all can hear me. Sorry, I am so late. I am not at home, not streaming from home. If you guys can tell, hold on a minute. I don't even know if you can hear me. Yeah, but I'm not streaming from home. Doesn't look like it's even streaming. I don't know. I don't know. Doesn't even look like it is streaming. Hold on. Let me see if I can. I can't even check to see if this thing is streaming. Uh, so this is the Lori Daybell. Um, see if this is I don't know what's going on with this screen, but this is the Lori Daybell. It should be her closing arguments and jury instructions. I don't know if we are streaming or not, but I'm going to add her to the stream and take myself off so you won't hear me. You will just hear the stream. Let me add the stream. Yeah, and that's kind of crazy because there it is. Okay, there it is. I'm just going to add the stream and then take myself off and start the stream. I'll be back.
That a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, The defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1. Physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and/or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and/or deadly physical force. However, physical force and/or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and/or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and/or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural, improbable, or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
So I don't know. Am I here? All right. Let me take her off. I don't know if y'all can hear me. Hopefully you can. I'm gonna go over and take her off the screen and see if they could fast forward.
I'll have these back in the courtroom around 12.
All right. So I don't know what. Definitely he's here. All right. So hi, hello, Allie, hello, Don. I believe that's Don is still here. Hold on 1 second. I'm trying to see where we are in this video. As you all know, I'm not home, so the setup is the setup is a little different for me. Difficult. I could not work from my phone. I couldn't use my, what do you call this? iPad. It wasn't working for me. I don't know what's going on with it. Okay, so we did that already. So let's see. Let me move it along and see what this judge is talking about. All right, so let's. All right, so Lori is arguing some. Hold on, y'all. Let me bring this over because Lori is arguing about some motions. And it looks like the motions have already been admitted. So this is what I want to see. The fool. All right, so let's go back over here. Let me bring her back over here. I'm not sure if you can hear me. It looks like my screen is not acting right when I just put myself on the screen, but Lori is arguing some. Oh, okay, I'm good. Thank you, Allie. I think Dawn is here. So I think Lori is arguing some motion. Let's hear what Lori is arguing. She's arguing about some motions that I believe that was already admitted into evidence. So I'm not sure why she's arguing about something that's admitted already. You can't. All right. And so I was unable to Twitter. I'm sorry. They got the notification, but I was unable to stream to Twitter today as well. So it's a day of struggle. Streaming is what they call it. Struggle streaming. But nonetheless, we are here. All right. Let me see what she's arguing. What motions is she arguing about? I believe she's a motion 20. She's arguing about. I'm gonna go off the screen so we can. I know because Ali said I'm low, so I mean they're low, so I'm gonna go off the screen and come back.
Yeah, ladies and gentlemen, we're going to ask that you take all of your belongings with you for lunch.
Anything else?
That's all, Your Honor. So,
Remind me to clarify which one it is when we get back from lunch, but your staff can look at or your team can look at the exhibits.
Arguing about an exhibit that they didn't. I don't know if they don't have the exhibit or what's going on with the exhibit, but they decided to go past it and they're going to lunch and coming back early. So I think that I thought she argued about an exhibit. I thought that's what I saw earlier. So let's see. I don't think that they're back, Allie. Yeah, I think it's just me and you here now. I think Dawn left. They should be coming back in a minute, though. I think he said 3:40. It's 3:47. Well, he said 12. It was 12:40 their time. Oh, so they have it up here on the screen until 4 a.m. 4 p.m. All right, let me. Yeah, they're on lunch until 4. And that's what Lauren Crime is saying. Were we watching Lauren Crime or Court TV? Court TV. So Court TV said that they're they're on lunch until 4. I thought the judge said 3:45. Also, they have not started closing arguments yet. Closing arguments are going to be after lunch. He sent them to lunch early, and he's going to be doing closing arguments. They get to set their own schedules about what time they want to deliberate to after the closing arguments. So we'll see what happens. Only thing about this stream, if I end it and come back at 4, I would have to start a whole new stream, which this one didn't start off worth anything anyway. So that's the only day. Oh, that's good, Allie. Thank you for that. And just let them know that it's normally not like this. I'm normally streaming from my studio. And I was trying to, I didn't bring my other headphones, and my Bluetooth headphones will not fit to my computer. So I'm just feeling all kinds of wacky today. I don't know why I don't know why my iPad would not work. I couldn't even log on through my phone, so I'm not sure why it was giving me such a headache, but it did. I think it was the judge's call, right? The judge decided that he was giving them, he was going to do jury instructions first, which he just did, and then go on lunch, and then do closing arguments. So, the state starts off with closing arguments, and then Lori will have her time. I don't know why. I thought that they said 3:45, but Court TV is saying 4 o'clock. But I thought he said he was going to bring them back in about 3:40, unless I heard wrong. I thought he said at 3:40. No, I'm not trying to sign in. My my brother may be trying to sign. Are you trying to sign into YouTube? I don't know what that's going on, but I don't know why Court TV is saying. Let me go to Law and Crime to see what they're saying. Because Law and Crime, I thought was saying, Law and Crime is saying, yeah, Law and Crime is saying 3:45, but then they're saying that they're saying, are they saying 4:15? That's crazy. So Law and Crime has up that they're going to be out to 4:15. But that's not. Oh goodness, y'all didn't tell me that we have another they had another pow at Florida State University. That's horrible. That's horrible. I did not know that. In other news, Diddy was denied delaying his trial. So yeah, for always had gave me a case that I think is going to be exciting. I looked it up. She emailed me about a case about a young lady named Lori, as a matter of fact, who was unalived, and her father reported her missing. Come to find out, the father is the one that was arrested for unaliving her. I'm still looking into the story because it's fairly new. I think because from what I got, she went missing like last year. So I think we're going to be finished with this trial today. I think I'm going to probably just talk about that one. What? Allie, you should have texted me and told me that. What? Oh my goodness, my head hurts. Nicole, I think it's more for the RICO than it is for anything else. I don't think. I think it's more for. Oh my goodness, I did not know that. Allie, where did you hear that at? Am I living under a rock? I have been. Shout out to everybody that asked me about my mom. She's home, so this is where I have been. And maybe I have been living under a rock because I did not see that, Allie. Let me go on over here. But you know what is so crazy? When they talked about the trial on the news, they didn't even mention Brian Steele. They didn't mention that Brian Steele. They just mentioned that the judge said no to him They wanted to push his case back like 3 to 5 years, they were saying. And the judge said no. Let me see. Oh well, I gotta look that up, Allie. Joined. Oh, that is I cannot. Hold on. See, I see it on TikTok. Let me see. Let me go to news. So they said Brian Steele was at the hearing. Oh yes, send it to me, Allie. I see where it says that Brian Steele was spotted at the hearing. Now is he laying low? Do you? Oh, let me go. It looks like Megan Kuniff has it. Or if you send it to me, I'll get it. But it looks like Megan Kuniff has some stuff up on Twitter. Let's see. Did y'all hear about the Tory Lanez hearing he had for the YouTuber that Megan Thee Stallion is suing? He got in the what is it called? My goodness, that's something that I wanted to go over too. She had a hearing, and Tory Lanez is called because she's being charged with conspiracy to she was paid to conduct this smear campaign against Megan Thee Stallion. She is a YouTuber, Tory Lanez. That girl, that's not my boy. Let me tell you, it is crazy. I'm gonna have to try to get the paperwork. I want to get the actual paperwork. So Tory Lanez had a hearing because there is a YouTuber by the name of Milagros Grams that's being sued for harassing Megan Thee Stallion, and instead of her stopping, she continues on YouTube, and she took it to station head to continue the slander, but not realizing that people are recording and giving the footage to whoever her attorneys are. And then she did a deep fake essay tape, not essay tape, a corn tape. She was sharing it on Twitter, and she actually was sharing the link on her station head. And the judge told her, you are going to need to see her in court. So, yeah, Allie, I have to. I'm gonna text you more behind the scenes because I have to. I'll. Yeah, that would be great. So basically, they had a hearing for her, but Tory Lanez is a part of this trial because allegedly he hired her. They have receipts. I saw receipts of about $3,000 that she was paid, and that's cheap for getting in that much trouble for Tory Lanez. And it was his responses to the questions at the deposition. That's what it is. It just came to my brain. The deposition. His responses at the deposition were crazy. He was asking, they were asking him questions, and he was asking the attorney, did she know about some decisions she was making before she chose the color that she was going to dye her hair? And he kept saying stuff like, your hair is really bothering me. I can't focus on anything because of your hair. So she was asking him a question or something like, did he meet with Milagros? And he was saying, define meat. Are you talking about meat like MEAT? Or are you talking about it was wild. I had heard a little bit of a content creator actually reading, and I fell asleep on it because I was tired. So I said I was going to see if I could get the paperwork myself and go over that, because Tory Lanez was totally bugging. They kind of put him out of the courtroom and said that he was not responsive, and they could not get the information from him that they needed. It was bonkers the way he was responding. And not only that, not that it was just bonkers, it could get him more time behind bars. So Tory, he's already supposedly being deported when he gets out. So Tory. Tory. So who knows? And let's see, Allie, if you sent something. I still can't. Nicole mess. What? I think now Dems are matching. So I think that now, if they are, is it for the? I think it's. Do you think that I can see Brian still? Is this more for I'm not sure. No, Nicole Westmoreland, really? Oh, wow. This is going to be very interesting if it is true. And we won't be able to do anything but get paperwork, because, there's no cameras allowed inside of a federal court. So far, they are starting the trial on May 5th. So we will have to see. Let me see. I can't believe that they're on lunch. Let me put something up here to say that they're on lunch, because people are clicking in and out like, what is going on? Listen, I'm not home, so you won't see me today. They are on lunch. I don't even have a ticker scrolling across. There we go. Okay, that looks a little doable. Let's see if we can get some. So we'll go ahead and strike my video from my old music. A whole mess. They strike my videos from my own music. And I have to add them. I'll add them. I add them to my list, and then they take the strike off. Let's see what Lauren Crime is saying right about now. They're still out to lunch. Yep, they're still on lunch. So, do you have Allie? Did you get that Nicole Westmoreland Um, because I didn't see that. I wasn't able to pull that up too. It's not out there. Out there. I thought Megan Kuhn had something up, but I don't know. I didn't see it on her page. I probably will have to look later. Really? I think I did because of, well, that's federal court, right? So that would have been state court what they just what they just had with yeah. I know the RICO thing, you know, so she's into the RICO thing, and I'm okay. So the RICO thing I can see, but I didn't know either about the federal, about her being part of federal court. I don't know how long she's been practicing. Don't make me do a deep dive on Nicole Westmoreland, because I will have to look into that and look into her. I just know that she's awesome. For him to have Brian Steele and Nicole Westmoreland, that's just a crazy lineup. Anyway. Crazy lineup. Well, one of his attorneys left. I know he's probably like, well, man, just for the attorney's sake. But he never really said why he left. It could be that maybe the defense that Diddy is going with is something that he doesn't think that he can beat in a federal court. We'll have to see what happens with this case, because let's see what will happen. Allie, what you sending? Are you sending that text message, or are you sending it to email? Let me see. Oh, I see it. I see it. Thank you. So I see her showing up with Brian. Oh, hold on, Nicole. So it's basically okay. All right, so she showed up. No, I got it. I just saw it. So it was very brief, but that's something that we're gonna keep on. Something that we'll keep. That's something that we'll keep down. Thank you for that, because they didn't really say anything. But wow, that's interesting. I did not see that. Like, I have not been on. You see how late I put up the thing for Lori yesterday, because I was not. I did some stuff on. I posted some silly stuff on Insta, but I have not been on there like that. That is so interesting. So they haven't made a formal announcement. I think Brian. I think Steele was something more that they came out and said. Or have not said, because I know that where did we see that at first, Allie, about Steele for joining the Diddy team? Where did we see that at first? So do you think, I'm wondering now, are they going to like become like even though they all work for themselves, I'm wondering if they're going to become like some type of dream team or something, where they all pool together and like. Now I'm going to have to set up my interview with Jim again, happily angry attorney, lawyer. I spoke to him like briefly the other day. He was more, oh, Thugger Daily. Okay, yeah. And more than likely, Thugger Daily is on point. So his stuff is, and if it's not, he normally corrects it. So that's why I like him. See, I haven't been anywhere like really looking at anything. I'm at you're gonna make me bring Jim back before. Even though he said that they should hear something about Moontooth's trial, Moontooth's case this week. And if so, I definitely have him on here for that. But then about what he thinks. And Dog just came out with some. Did you see the new clothes he has out with Brian on it? What would Brian do? But Brian was a model for Spider, so I don't know if anybody knows about Spider, but that is Young Thug's clothing line. Brian is a model for Spider. I'm so mad about this setup today. Like, I cannot believe like nothing works. And I thought I tried it the weekend. Like just yesterday, well, I guess if I watched the video, it would work. It's not the same. You know what? I may have to go straight. That's what I should have did. I should have, and I don't want to keep doing this. This is the whole point. Like StreamYard. So I'm using my other streaming service, but it's like not. It is so crazy. Oh yeah, I loved it too. Like, but he was already modeled. He modeled for Spider. That was over the top when he put those photos out. And he had on the his Spider gear, but now he has out the Brian Still merch. It's crazy. So Allie, did you see have you been on any of Little Woody's lives? Yeah, I'm with you on that one. Have you looked at any of Woody's lives though? How he's being harassed. It's crazy. They pull him over every day for no reason. They have no legal reason about why they pull him over. It's crazy to see it because he turns the camera on each time. And he said that he was going to do something about it, but I hope that he's safe out there because the way they're doing it is something I have not seen like in a long time, like every day, or either if somebody else is driving, like, he has more than one car. After this trial, he came up. Like, that's the only thing I can say. They are, every time somebody's driving one of his cars, they pull the car over, whether he's in there or not. Oh, my tab is not responding. That is crazy. I'm trying to put my StreamYard up to see if it'll be any different. Because right now, the service that I'm on is giving me such. Yeah, the other day it was really bad. The other day he went on. I'm not sure if you saw that one the other night. I think it was Thursday. Um, and they pulled him over, and he asked him, was it the other day that they asked him? He asked him, was he being detained? And they told him to close his eyes and believe that he's being detained. I was like, what? That's crazy. Close your eyes. Close your eyes and imagine that you're being detained. That's what he said. They told him. I said, what? I'm gonna have to go back over here to StreamYard and see if I can StreamYard from my iPad. That's where we going. I'm in this one that we on, and I'm gonna have to just go live on the daggone StreamYard. Let me see something. Hold on. StreamYard doesn't have any of my and if I have StreamYard, I have a free account. But it's going to be problems if I can go on StreamYard and can't. Well, you know what? He was talking about so many of them at one time. He was talking about but the last one where he went live afterwards was he was in the park, and they came and said they smelled marijuana. He's like, nobody smokes that stuff. So what do you mean? And they were saying something to him, and he just was like, this is not true. Like, this is crazy. Oh, wait a minute. Let me see something. No, I'm not doing that right now. Let me see something. I'm gonna have to switch to StreamYard if it'll go, because this is getting on my nerve, this laptop, because you can't really hear like I wanted to hear. So what do I have? Lori Vallow's closing, and I wanna hear it clearer than what it is. And I know people are coming over here like, what is going on? And I'll fill in the blanks later. I'll let you know in one moment if I'll be going to StreamYard, because I can't. In my other system, the other one that I have, I can't use. I only can use it with. Well, I will be able to use it with my iPad, but I'm not. Let me just see, because I don't know with StreamYard, I might have to. And it's going to have like the StreamYard logo on it. It's crazy. Hold on. Let me turn my camera off. Ooh, stop camera. That's ugly. Yeah, I think we're going to go over to StreamYard because it's using my, I think I'm going to end this one and go over to StreamYard just for this, because I really want to hear. And I don't like talking like this. It's crazy. Yeah, I'm over on StreamYard, Allie. And if somebody else is here, come to join my other stream link, because I'm going to shut this one down. All right. See y'all over there. Let me turn this one off. I don't know if it's this laptop or not, but you got me, Allie. I see you on the other one on StreamYard.